this, Karnataka's Deputy CM D.K. Shivkumar said party workers have got us to power. They will get power. It's about status. More will get it. At least he's honest. Imagine waking up tomorrow as an MLA with a ministerial status. Not being made a minister, but having the status. This is what you'd get. A rupees 50,000 monthly salary, rupees 80,000 for house rent, rupees 20,000 for maintenance and staff, rupees 3,000 hospitality allowance, rupees 2,500 a day for just showing up, and 1,000 liters of fuel for free every month. That would otherwise cost you a lakh. Assistants, secretaries, and vehicles included. Sounds like a dream, right? But let's remember that there's a catch to get all these perks with a salary. You'd have to, first contest an election and then win that election. Except in Karnataka, where the winning elections part has become optional by the looks of it. And a ministerial status seems like a return gift for loyalty. You see, on 10th February 2026, Karnataka's BJP leader of opposition R. Ashoka called out the state government for handing ministerial ranks to 149 Congress leaders in an assembly that only has 136 Congress MLAs. The math doesn't add up. 54 of these people are not even elected representatives. That is, they are not even members of the legislative assembly. They're party appointees who've been placed in state bodies and handed ministerial status. To this, Karnataka's Deputy CM D.K. Shivkumar said, they have got us to power. They will get power. It's about status. More will get it. At least he's honest. But this action doesn't just hand out status. It hands out salaries, allowances, fuel, staff, rent, and a plethora of other perks, adding up to roughly around rupees 50 crore a year, as per Karnataka's leader of opposition R. Ashoka, presented in the assembly. If doubtful, just go back to the beginning of this video and calculate the cost of all the perks we just mentioned. And keep in mind, the state's debt is expected to reach around rupees 7.6 lakh crore by the end of March 2026. Seeing this piece of news, we got curious about these ministerial appointments in general, both in the present and past. Certainly, there must be some rule to prevent excessive appointments from happening. And this landed us to the 91st Constitutional Amendment Act of 2003. So in today's video, we are going to tell you all about the 91st Amendment. At the national as well as the state level, every government has a Council of Ministers, which is a constitutional body. Let's start here. The Council of Ministers is a body of individuals responsible for policy decisions, legislative proposals, ministries, administrative actions, including rules, orders, implementation of schemes, etc., etc. The said Council of Ministers consists of three categories of ministers, namely the Cabinet Ministers, Ministers of State, and the Deputy Ministers, led by the Chief Minister or Prime Minister. However, this Council of Ministers cannot be limitless or countless in number at any level of government. Not anymore, at least. There are certain limits. At the national and state level, the strength of the Council of Ministers, including the PM or CM, cannot exceed 15% of the total strength of the House. Moreover, to ensure effective governance in smaller states like Goa or Sikkim, the number of ministers cannot be less than 12%. The upper limit of 15% and lower limit of 12% imposed on the strength of the Council of Ministers is courtesy to the 91st Constitutional Amendment Act of 2003. It amended Articles 74 and 164 of the Constitution, which deals with the Council of Ministers in India's parliamentary setup at the national and state level respectively. But why did such an amendment come into place? Well, the answer funnily lies somewhere close to the news we started this video with. That is the number of people handed out ministerial status, even exceeding total number of party legislators. You see, before 2003, India was dealing with the era of jumbo cabinets. Since there was no legal limit on the number of ministers, assemblies had bloated cabinets. This came alongside the rise of coalition politics in the 1980s and 90s, where ministerial appointments were offered simply to keep coalition partners happy or to buy the loyalty of potential defectors. Basically, ministerial wives had become the ultimate freebies for politicians. No performance expected, just the simple promise of not bringing the government down before lunch.
Khatam, bye bye, tata, goodbye.
Uttar Pradesh was a leading example of this at the time. The year was 1997. Kalyan Singh became the CM in September. However, the BSP withdrew support a month later from the coalition. Kalyan Singh had to face a floor test to survive. He immediately inducted 70 ministers. That is almost every MLA who supported him. What followed next was a political comedy as his cabinet reached 93 ministers, 1/4 of the total strength of the assembly. What's so funny about this? While he did win the trust vote with 222 MLAs in support, he faced a problem to actually find portfolios for his cabinet colleagues. What came out of this was one of the most iconic floor tests in Indian political history.
The assembly became a battleground as politicians hurled microphones and chairs at each other, ran for cover.
But this did not end here. If anything, it set a precedent. In 2003, the former CM of UP, Mulayam Singh Yadav, broke Kalyan Singh's record of 93 ministers by inducting 91 ministers in a single expansion, which brought the total size of his Council of Ministers to 98. He said he was even ready to expand it further to 105 if Congress decided to join his government. Alas, the 91st Constitutional Amendment came into force in 2004, and one can only imagine Yadav's inner turmoil while dropping 31 ministers from his extra jumbo Council of Ministers. Bihar too followed the Kalyan Singh trend in 2003 when the then RJD Chief Minister Rabri Devi's Council of Ministers had 82 members, including 30 cabinet ministers. After all, she had to accommodate Congress as a coalition partner too. Similarly, Sushil Kumar Shinde's Democratic Front government in Maharashtra had 69 ministers in 2003, even though he did mention that he would have a small ministry. However, this was not just a state level issue. At the national level, the third tenure of Atal Bihari Vajpayee in 1999-2004 witnessed the largest union council of ministers in Indian history. At one point, the council of ministers at the centre comprised of 88 ministers under the National Democratic Alliance, which had over 24 coalition partners. Though this fluctuated between the 70s to 80s due to various cabinet reshuffles. Clearly, the jumbo cabinets were becoming a political trend and the most creative workaround for politicians. Why? Ministerial appointments became the ultimate freebies for politicians. It worked as bribes for defectors, ministerial status with zero portfolios and responsibilities, a horse trading paradise, and a loyalty lollipop. The result? The state exchequer ended up with a hefty bill for all this creative statecraft. Something had to be done. This is when the Vajpayee government issued a resolution on February 22, 2000 to suggest possible amendments or improvements to the constitution without altering its basic parliamentary structure. What followed next was the National Commission to review the working of the constitution, set up under the chairmanship of former CGI M.N. Venkatacharya within the same month. It was set up to understand how the constitution can respond to the changing needs of governance and socio-economic development of modern India. The committee submitted its 1900-page report on 31st March 2002, and one of the many observations was on the abnormally large council of ministers constituted, which had to be prohibited by law, as these appointments were often driven by political considerations rather than administrative efficiency. It proposed that the ceiling must be fixed at maximum 10% of the total strength of the House. However, when the amendment was discussed on the floor, Arun Jaitley remarked that though the 10% is a healthy convention, but at times political parties and governance, particularly coalition governments, found it difficult to adhere to that size. Therefore, political realities of coalition governments at the time led the parliament from all sides of the aisle to settle on 15% to the total number of members of the House, be it the centre or the state, leading to the passage of the 91st Amendment, which introduced Article 164, Clause 1A to the Constitution, which limits the number of ministers in the Council of Ministers. Result? While the states were given time till 2004 to prune their ministry sizes, different states were impacted differently. Remember Mulayam Singh's cabinet shrinking from 98 to 67? Something more interesting happened in Arunachal Pradesh. About 40 MLAs from Congress had joined the BJP overnight in August 2003, thereby creating the first BJP government in the region. All of the 40 were given ministerial posts. However, after the mandatory ministry downsizing, their brief unity disintegrated and the president's rule was imposed. So we could probably even say that this amendment tested intentions and loyalties towards voters overpowered us. Fast forward to 2026. It's been 12 years since the 91st Constitutional Amendment came into place, and one can safely say that the era of jumbo cabinets is largely over. However, the era of doling out ministerial statuses clearly did not end. State governments a decade back found loopholes to the 91st Amendment. Loopholes in the guise of ministerial status doled out in the name of parliamentary secretaries. Parliamentary secretary often holds the rank of the minister of state, works closely under the direction of cabinet ministers, and in addition, they also have department-related public and house duties to perform as well. While the parliamentary secretaries have a number of responsibilities and rights, they are not involved in any major government decisions, nor do they partake in cabinet meetings. However, they hold the ministerial status, have the same entitlements, and are assigned to a government department. States like Manipur, Himachal Pradesh, Mizoram, Assam, Rajasthan, Punjab, and Goa are some states that have instituted this post in the past. But how do we know that this post is truly a loophole? Let's take a few examples to understand this better. Let's begin with the example of Delhi, where this spurred a row in the past. Delhi specifically, by the way, has a 10% cap on the strength of Council of Ministers under Article 239AA of the Constitution, which means that it can only have 7 ministers, including the CM. In 2015, the Aam Aadmi Party-led government appointed 21 MLAs as parliamentary secretaries. Considering that Delhi Assembly only has 7 ministers, 21 parliamentary secretary appointments seem like a bit of a stretch. Prashant Patel, a Delhi-based lawyer, challenged these appointments. In response, the Delhi Assembly passed the Delhi Member of Legislative Removal of Disqualification Amendment Bill 2015, which excluded the parliamentary secretaries from office of profit with retrospective effect. However, the then President Pranab Mukherjee declined assent to the bill. Furthermore, in 2016, the Delhi High Court struck down all the 21 parliamentary secretary appointments as illegal. This wasn't the only instance. A decade earlier, the Congress-led Assam government enacted the Assam Parliamentary Secretaries Act 2004 soon after the 91st Amendment came into place. 13 years later, in 2017, a landmark judgment changed it all. In the case Bhimalangshu Roy versus State of Assam, the Supreme Court ruled that the Assam State Legislature did not have the power to create the office of Parliamentary Secretary, thereby creating extra constitutional posts. The court observed that the act bypassed the 91st Constitutional Amendment and created a second layer of ministers, declaring the Assam Parliamentary Secretaries Act 2004 as unconstitutional. Similarly, in 2016, the Punjab and Haryana High Court had quashed the appointment of 18 chief parliamentary secretaries who were appointed by the 2012 Prakash Singh-led Shiromani Akali Dal BJP coalition government in Punjab. Recently, the Sukhwinder Singh Sukhu-led INC government in Himachal Pradesh had appointed 6 chief parliamentary secretaries. In November 2024, the Himachal Pradesh High Court set aside their appointments by quashing the HP Parliamentary Secretaries Act 2006. In fact, the same action had been quashed even 2 decades ago, as the HP High Court had quashed the appointments of 8 chief parliamentary secretaries and 4 parliamentary secretaries in 2005. With all these instances we mentioned, did something catch your eye? Every time a parliamentary secretary has been appointed, eventually, even a decade later when challenged, the courts have struck it down. Why is that so? Well, the institution of the office of parliamentary secretary has no statutory origin, nor does it derive authority from the constitution. In India, the president or the state representative, that is the governor, administers the oath to the council of ministers and not the parliamentary secretaries. Instead, the parliamentary secretaries are appointed by and under the PM's discretion. They were first appointed by India's first PM, Shri Jawaharlal Nehru, and worked as deputy ministers with undefined power, as per a 1997 study by the Ministry of Parliamentary Affairs. This, however, remained an archaic practice, as the last notable appointment of a parliamentary secretary to the PM was done in 1990. So when the 91st Constitutional Amendment was adopted, the ministerial appointment doors dried up. States just rebranded them in the form of parliamentary secretary, a ministerial status without any actual responsibility of the minister. Here's the first problem. States don't even have a parliament. They have legislative assemblies, So the very title Parliamentary Secretary is a borrowed one whose appointment is done by the PM for the PM, and if we are following UK's practice, then to train a future PM. The nomenclature alone is constitutionally embarrassing, which has been stated by a plethora of high courts across the length and breadth of India. Moreover, when it comes to ministers, again to reiterate, states do not have the capacity to make these unconstitutional appointments, as the Council of Ministers in a state are appointed by the governor as per Article 164. It speaks of no parliamentary secretaries, no creative additions. And to be honest, nor does this loophole seem to be sustainable, as courts keep striking them down in most cases when challenged, and especially when exceeding the 15% limit. Besides the appointment of parliamentary secretaries, there has also been a trend of doling out ministerial status to chairpersons of state boards and corporations along with advisors. Here's a balanced way of understanding this. The number of ministers isn't the problem itself. If anything, a larger, more complex population arguably demands more hands on deck, more ministers, more scrutiny, more responsibilities, more people to administrate. But, and this is a non-negotiable, every addition must be justified. Not politically convenient, but justified. Talking of the constitution, we know that it is meant to evolve, which is why it's called a living document. Perhaps it is time for the 91st Constitution Amendment to also evolve, since the law's very definition presents a loophole even after multiple high courts have struck down the appointments like the parliamentary secretaries. For instance, the 2021 Rajasthan Congress appointments of 6 CM advisors under CM Ashok Gehlot did not cross the 15% threshold for ministers, which is why it wasn't challenged in court, even though these appointments had no statutory position. Similarly, in 2023, a petitioner challenged in the Karnataka's High Court on the appointments of certain political secretaries, chief advisor and media advisor to the chief minister of Karnataka. The division bench dismissed the petition and held that the appointees are not ministers in the constitutional sense, they are only assistants to the chief minister. And therein lies the problem. The court isn't wrong technically, since these appointments have no statutory origin. They cannot be counted as a part of the Council of Ministers, nor do they fall within the 15% limit prescribed by the 91st Constitutional Amendment, since these aren't ministerial appointments. The law, as it stands, simply does not reach them, thereby creating a quagmire when it comes to the 91st Amendment. Quagmire currently being utilized to political horse trading and making jumbo de facto ministers, similar to the case of Karnataka today, a state grappling with 149 ministerial status holders. So find out how many ministerial status appointments your state has and share it in the comment below if it crosses the 15%.